Hello, I'm Melanie Fontes-Rayner. I'm the Director of the Office for Civil Rights at the U.S. Department of Health and Human Services. Since the Supreme Court overturned Roe v. Wade, my office has heard from providers, patients, and others about their concerns about their ability to access health care and its impact on their privacy. We've heard from patients, providers, major medical organizations, and organizations representing thousands of individuals nationwide. They are concerned about their medical information being used to target and track what health care they receive. As a result, individuals may hesitate to interact with providers, health plans, pharmacies, and others in the provision of care out of fear that their medical information will be tracked and/or shared with state agencies, law enforcement, or others simply for the mere act of obtaining, providing, or facilitating lawful reproductive health care. HIPAA was created to allow for the exchange of medical information, which helps improve care coordination and health outcomes. As part of this, Congress contemplated possible medical privacy issues and required HHS to establish a privacy standard. That's why today, HHS issued a final rule to update that standard with the HIPAA privacy rule to support reproductive health care privacy. This update prohibits HIPAA-covered health care providers, health plans, clearinghouses, and their business associates from using or disclosing an individual's protected health information to conduct an investigation into or impose liability on any person for the mere act of seeking, obtaining, providing, or facilitating lawful reproductive health care. Here are some examples that demonstrate how this new rule works. If a person receives reproductive health care, such as a pregnancy test or treatment for an ectopic pregnancy, and that reproductive health care is lawful in the state in which they receive such health care, that information about that health care cannot be used or disclosed by that health care provider or health plan for an investigation to impose liability on the individual or the provider. Similarly, if reproductive health care, such as contraception, is protected by the Constitution, that also may not be used or disclosed per the new prohibition in this rule. Of course, there can be many examples, and these are just a few. No one should live in fear that their conversations with their doctors or that their medical claims data could be used against them simply for receiving lawful reproductive health care. Until this rule takes effect, the current privacy rule under HIPAA permits the use and disclosure of your protected health information, including reproductive health care information in certain circumstances, but generally does not require it to be used or disclosed. We issued guidance in June of 2022 to help protect patients seeking reproductive health care as well as providers on the current state of the rule. This guidance addresses how the HIPAA privacy rule protects individuals' health information relating to abortion and other reproductive health care, making it clear that providers are not required to disclose this information to third parties, and there are conditions that are required to be met before it can be disclosed. HHS and OCR are here to help protect you and your reproductive health care information and privacy. If you believe that you or someone else's health information privacy rights have been violated, you may file a complaint with my office at HHS.gov/OCR. Thank you so much.
Produced by the U.S. Department of Health and Human Services.